unprecedented, invasive. I'm just going to throw in the words crazy and insane. Those are words that both I and a federal circuit court, multiple judges used to describe what California came up with in this decision. Ultimately, the good guys win, but narrowly, because there was one judge in a 3-judge panel who wanted to uphold this crazy law. You aren't going to believe this because, like the Hotel California, you can check in, but you can't check out. Guys, let's get into it. All right, so we have to go back to the original sin. We're talking the Adam, Eve, Garden of Eden moment. It's California. That happens like every day. But in this case, we're going back to 2016, where California voters approved Proposition 63, establishing a system where every ammunition purchase, every single box of cartridges was subject to a background check run by the Department of Justice. Purchases required completion of either a basic, standard, or certificate-based check with associated fees ranging from $1 to $19 or more, additional administrative processing fees, and in some cases, significant delays because, hey, why not? What's the government without some delays? Most importantly, this background check was not a one-time requirement. This wasn't a, hey, do it once on January 1st and you're good for the year or 2 years or 5 years, like any concealed carry license. California residents had to submit to this check every single time they purchased ammunition, whether in person, online, or out of state. I had to look that up, folks, because it's not often that I'm at a loss for words. I'm an attorney after all, but I'm telling you, when I found out that this applied to out-of-state purchases, like if you leave the state, right. California really out-California themselves. I'm going to have a quote for you from the court later, so be sure to stick around from that on exactly that point. So the question put to the Ninth Circuit Court of Appeals is pretty straightforward. Does California's background check law go too far in restricting the purchase of ammunition as a constitutionally protected right to keep and bear arms? As a note, the district court put a permanent injunction on this at the district court level. So when we have the federal courts, we're talking about the federal district courts. These are the federal trial courts. We're in the circuit court, Ninth Circuit Court of Appeals, okay? And then above that, we go to the U.S. Supreme Court. The U.S. Supreme Court only hears about 1% of cases. So these circuit courts of appeals opinions are very important because they tend to be very final. That's why. So we're starting with the high ground here, so to speak, because the Second Amendment basically carried the day absolutely carried the day down in the district court level. But now we're up to the Ninth Circuit. So the first question here is an obvious one if you have been with us on this journey going through Second Amendment to a law, and that is whether or not the law is covered by the Second Amendment. Because if what we're talking about, being regulated, restricted by the government, is not protected by the Second Amendment, then we're not doing a Second Amendment Constitution analysis. I don't know what we're doing, but it's not that. So step one, does the Second Amendment protect this? We're talking about purchasing ammunition. As the court stated, and I quote, "The right to keep and bear arms necessarily encompasses the right to have ammunition." Period, end quote. That sounds really straightforward to you and me. But this is California we're talking about. So, I'll try to use smaller words sometimes. Forcing law-abiding citizens to jump through repeated regulatory hoops to purchase ammunition, the court reasoned, is a meaningful constraint on that right, and therefore it is subject to Second Amendment analysis. So moving to the second point, now that we know that California has to deal with the Second Amendment, what happens next? California now bears the burden of proving that its law was consistent with the historical tradition of gun regulations in the United States. And keep in mind, these have to be representative of the nation's historical tradition. You can't just find one little speck of a county somewhere that came up with something that's not representative and use it to justify anything and everything for the entire country someday. No. And also keep in mind, we're talking about early republic, so pre-Civil War, pre-Civil War, ideally colonial times, closer to the passage of the Second Amendment in 1791, the better. There's exceptions to everything, as the Supreme Court has said. Not my words, don't flame me, but that's the gist of this, okay? California offered a range of flimsy historical statutes as potential analogs. Founding era loyalty oaths, surety bonds for dangerous individuals, kind of like bail, basically. 19th century licensing or record keeping for arms dealers, you name it. But none of these, the court found, came close to justifying a burdensome, universal, repeated background check for every single ammunition transaction. Loyalty oaths were imposed as a one-time test of allegiance. Take the oath, and you could possess arms. Surety bonds were restricted to individuals judicially determined to be dangerous. Licensing requirements were imposed on vendors, not on every single individual buyer. Nowhere in this nation's history, the court concluded, not Tom Grieve, the court concluded, although I agree with this, has there been a regime, a law that was so persistent, so universal, and so invasive as what California tried to pull here. In fact, the court observed that California's system is unprecedented in American history. In fact, California, as I mentioned before, follows you. Yeah, California follows you. It's no longer a place on a map. It's a state of mind, okay? Or maybe a bunch of handcuffs. From the opinion, the regime, meaning the law, applies not only to every transaction in California, but also to ammunition purchases by California residents outside the state. It requires California residents to pay for and complete an in-person background check before each ammunition acquisition. Though not all the rules comprising California's ammunition background check regime impose delays on their face, they do not require California to approve checks within a certain time frame. So that's a direct quote from the case right there. What's that saying? Two things. Number one, you can't escape California. It's like the Hotel California. This is probably where they got this from. This is the Hotel California of gun laws. You can check in, but you can never check out, I guess, unless you shred your driver's license and move to Texas, okay? Or something like that, or Idaho too, and Arizona. Aren't those the states people flee to? But at any rate, though. And the second thing, of course, is there's no time requirements for this background check. So if they want to drag their feet and make this a 2-week thing, 3-week thing, hey, whatever, that's on you. You want to go buy ammunition the next day? Guess what? You get to start again the process. Now, I want to focus on one of California's core defenses, a defense that has been invoked across the country in litigation, in courtroom over firearm regulations, shall issue licensing. California argued that its ammunition background check regime is analogous to shall issue permit systems for concealed carry. And that's important because the Supreme Court has called such systems presumptively lawful and has left them largely undisturbed, notwithstanding that whole June 2022 Brune decision. But, that was a May issue and there's other things, but we'll press on. But let's be clear on what shall issue actually means. Again, small words. In a true shall issue regime, a law-abiding, responsible citizen, good guy, applies, passes a background check, and receives a permit, typically valid for years, 3, 5, 7, 10 years, you name it, which allows the individual to exercise the right to carry with some general conditions attached. Don't carry here, don't carry there, that kind of stuff, okay? And I'm not getting into those weeds right now. You do not have to return for approval every time you step outside your home with your firearm. See one of the big differences there? California's ammunition law, however, is fundamentally different. It does not grant a permit that allows for the exercise of a right over time. Instead, it imposes a recurring requirement, a new background check, a new fee, a new risk of denial or delay for every single act of ammunition purchase. As the court noted, the how of California's ammunition background check regime, which gives an ammunition buyer permission to buy ammunition one time, sometimes within an hours-long window, is not analogous to the how of a shall issue licensing law, wherein a person receives a license that is valid for years and years and years at a time. We'll have to see if California tries to appeal this to a relatively pro-gun Supreme Court. And if that court takes it on that 1% to 2% chance, what does it choose to do with it? It is very important that we shut these laws down in their infancy, not after they grow and spread like a plague on the Constitution across this great land. I want to thank you for sticking around. Be sure to hit that like button. Let me know down below, what do you think is going to happen? Do you think California is going to try to appeal this? The case is Rhode versus Bonta. You'll find it down in the description box below if you wish. And of course, for all you enterprising scholars out there, we have our ever popular quote of the day. This one comes from Leonardo da Vinci, who said, quote, "While I thought that I was learning how to live, I have been learning how to die." A little different. Went thought-provoking in this one. Let me know what you think about that. I look forward to seeing you in the comments section, and I'll see you in the next one. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.